Rules Committee come to order, and good evening and welcome to the Rules Committee. Tonight we will be considering H.R. 1180, the Working Families Flexibility Act of 2017. State and local government employees have long been able to choose paid time off as compensation for working overtime hours. Unfortunately, through an outdated federal law which prohibits private sector workers from enjoying this same benefit, we are here tonight. H.R. 1180 amends the Fair Labor Standards Act of 1938 to allow private sector employees to offer employees the choice of paid time off in lieu of cash wages for overtime hours worked. This common sense legislation will provide the flexibility needed, I believe, today and throughout the 21st century work environment. It ensures the American worker has the flexibility needed to perform and exceed in the workplace while simultaneously maintaining commitments at home and to their family, actually making both work. All existing protections in the Fair Labor Standards Act are maintained under the legislation, and an employee who prefers to receive cash payment for overtime hours, as they always have, is free to do so and to continue. I would like to welcome back to the Rules Committee the gentlewoman who sat here for at least 10 years, the gentlewoman who was Vice Chairman of the Committee, Virginia Fox, as well as Congressman Jared Polis, who sits on the Rules Committee, two really of our most favorite committee members here at the Rules Committee, and without objection, anything they have in writing will be entered the record. I look forward to their testimony to make sure we get this right, but more importantly, we would welcome both of these important members who have extensive knowledge not only how the Rules Committee works, but why we're actually here. And before we defer to the gentlewoman, the young chairman of the committee, we'll defer to the ranking member, the gentleman, for any opening statement he chooses to make. The gentleman is recognized.
Well, because I respect the gentlelady who served on this committee for so many years with great distinction, I will be very brief and spare her my usual diatribe on this bill, which I don't favor at all. I mean, we have done this bill a couple of times already in this committee over the years I've been here. I think it is tantamount to an assault against working Americans by trying to undermine overtime pay and worker protections in the 40-hour work week. I think it's a bad idea, but I think I've said that a few times in the past when we reviewed this bill, so we could just rewind the tape and I'll save everybody some time. And but I do say to my colleague, Ms. Fox, it's great to see her back here, and we miss her, so I yield back.
Thank you very much. Appreciate the gentleman's comments. Ms. Fox, we're delighted that you're here. We moved in a new vice chairman over here, but you're still missed. And Mr. Polis, if he arrives, will tell you you're one of his very favorite committee chairmen.
One of my very favorite committee chairmen is Dr. Fox from the Education Board.
That's exactly what I was talking about. And so with great accolades, we welcome the young chairwoman, and the gentlewoman's recognized.
Thank you very much, Mr. Chairman, and thank you.
We practiced this about 4 or 5 times before you got here, and it worked, didn't it?
It did.
There you go.
Mr. Polis is Johnny on the spot. I want to thank the members of the Rules Committee for allowing me to speak in support of H.R. 1180, the Working Families Flexibility Act of 2017. And Mr. Chairman, you did an excellent job of summarizing the bill, and I appreciate that. I will not belabor the point, but I hate to let this great statement that the staff has put together go to waste, especially because it has some wonderful alliteration in it. This proposal is about freedom, flexibility, and fairness. Workers, not the federal government, should have the freedom to choose what's best for them and their families. Hardworking men and women need more flexibility to balance work, life, and family, and there should be fair workforce policies that don't put private sector employees at a disadvantage to those in the public sector. This bill will improve the quality of life of many Americans by offering workers eligible for overtime a choice between paid time off and cash wages. Outdated federal labor rules currently prohibit private sector workers from exercising this choice, the same that public workers have. More than 30 years ago, Republicans and Democrats amended the law to give public sector workers the option of comp time This was a positive step, but it created a double standard. It's time to erase this double standard. That's exactly what this proposal does. Some of our colleagues claim this bill undermines existing overtime protections and fails to provide safeguards for workers. That's simply not true. The decision to choose comp time is completely voluntary and requires a written agreement between the worker and employer. Those who want to continue receiving cash wages as overtime pay are always free to do so. Those who want to turn their overtime hours into paid time off would accrue comp time at the long-standing overtime rate of time and a half. Additionally, employees have the ability to cash out their comp time whenever they choose. They can also switch back to receiving cash payments for overtime if their needs change. This bill maintains existing worker protections under the Fair Labor Standards Act, as you said, Mr. Chairman, and explicitly prohibits employers from coercing workers into electing comp time. Employers engaged in any form of intimidation would be liable for double damages and any attorney fees incurred by an employee. All we're doing here is giving workers a choice. No one, Republicans nor Democrats, should think they know what's best for individual workers and their families. Let's let the American people decide. I urge the members of the committee to support H.R. 1180 and a modified closed rule for its consideration by the House. Thank you, and I'm happy to answer any questions.
Thank you very much. Virginia, I'm delighted that you're here today and would want to thank you. When you left this committee and assumed your chairmanship, not one person on this committee didn't think that they would be pleased to not only see you back before us, but would be eager to see you be successful. And I think today, whether they're for or against the bill, you've received the accolades of people who care much about your service and your vision and your fair play, and I want to thank you very much. Mr. Polis?
Thank you, Chairman Sessions and members of the Best Committee in the House, the Rules Committee. It's great to appear before you today with regards to H.R. 1180. If we wanted to start from the premise of empowering employees and giving them more say over their overtime, somebody should have thought of asking the employees and the groups that represent them. And this bill is opposed by every major workers' rights and union organization because, in fact, while it's being presented as offering employees an additional option, what it's actually doing is giving employers yet another opportunity to deprive their employees of their rights. The truth is, right now, an employee who takes time off from work can use their overtime to cover their expenses while they're out. They can use overtime, they can put overtime pay in the bank where it earns interest for them. And take time off from work later using that paycheck plus the interest they've earned to cover their expenses. This type of overtime deferral is effectively an interest-free loan to the company at the expense of the employee. Under H.R. 1180, if an employee accepts an employer's offer of comp time, she won't get a paycheck for her overtime. She'll get an IOU saying that she may be permitted to take comp time at some point in the future when it's convenient for the employer. In the meantime, providing an interest-free loan in the amount due to her. H.R. 1180 is written as a voluntary agreement, but let's keep in mind the reality that many employees would feel compelled to accept comp time, given the power differential between employees and their employers. It's particularly true because many of the workers eligible for comp time are paid very low wages. We, as you know, under President Obama's executive action, attempted to raise the thresholds on wages that are eligible for overtime, but that's now in flux. It's important to remember that this legislation only applies to workers who are eligible for overtime pay, so that's generally low-wage workers, since the overtime salary threshold has been allowed to fall woefully out of date. Furthermore, especially given that 90% of private sector workers are not represented by a union, many non-union workers feel that refusing to accept comp time can put their jobs at risk under this bill. And they simply wouldn't have the resources to fight back if their employer retaliates against them for their refusal to agree to comp time. So we worry about the use of comp time and employee preferences. So, again, it's easy to see why this might be attractive for companies wanting interest-free loans at the expense of their employees, but it's not easy to see how this actually benefits employees. And comp time is essentially an interest-free loan from the employee to the employer, repayable only when the employer decides that allowing the employee to take their comp time would not, quote, unduly disrupt business operations, a standard that's very loose and effectively allows the employer full say. What's more, there's nothing in this legislation that prohibits an employer from preferentially assigning overtime to employees who agree to comp time. Therefore, it would make it extremely likely that only employees who agree to get paid in comp time would be assigned to work overtime in preference to those who want to actually receive the overtime pay that's due to them. At the same time, because this legislation makes it easier for employers to assign overtime work, it's extremely likely that employers would assign excessive work hours to workers for whom they're a burden. The Fair Labor Standards Act established a 40-hour work week to prevent employers from requiring employees to work long hours away from their families. This legislation weakens the concept of the 40-hour work week at the very moment when it ought to be strengthened. It's time that we pass policies that support families rather than take additional resources away from families in the name of comp overtime. So instead of considering this legislation, which Democrats feel gives employees less time, less pay, less flexibility, Democrats have proposed a number of other pieces of legislation that would actually strengthen the Fair Labor Standards Act, raise the minimum wage, restore the overtime salary threshold to what it was adjusted for inflation, ensuring equal pay for women, providing truly flexible and predictable schedules and paid leave. And we're happy to negotiate with Republicans a true way to meet the stated goal of this bill, which is allowing employees more say over how they receive their overtime. This bill is not a bipartisan bill in committee, and it's not the way to do that. So in summary, while H.R. 1180 is packaged as providing flexibility for workers, in reality, the only flexibility it gives workers is the flexibility to forfeit their hard-earned pay at no interest to the company, or even worse, if a company goes bankrupt or goes out of business, employees might never be paid for the work that they've already done. I thank the Rules Committee for the opportunity to testify before you today, and I'm happy to take any questions.
Thank you very much, Mr. Polis, not only for your comments, but for representing the views and ideas that you believe fit the marketplace. Mrs. Fox, I spent 16 years in the what I would call free enterprise system, had lots of employees, 1,500 or so employees. I gathered what you were doing was a complement of not adding more or taking away any pay, but having a comp time that equaled what might have been the work that was done for time off for flexibility purposes, meaning I'm not trying to take money away from you, and you're not trying to take money away from me, and I'm not trying to take time away from you, and you're not trying to take time away from me, but it's of discretion if you choose, and it might be it's now springtime, or it could be for an employee, it's graduation time. And hey, boss, how about if I leave 2 hours early and I agreed to come in 2 hours early tomorrow? How is that taking money away unless I said to you, I will require you do it for more than 8 hours when you might get time and a half?
You know, Mr. Chairman, I'm totally flabbergasted by the opposition to this legislation by the Democrats, just totally flabbergasted, because they're willing for public sector employees to have this benefit, but not the private sector. And I will tell you, anybody who knows me will tell you that the most precious thing to me in the world is my time. And I think it's the most precious thing to anybody. You know, Mr. Polis said, oh, just pay people overtime and then they can buy what they want. Nobody can buy time. Nobody can buy time. If you want time to do things with your family, go to a ball game, as you said, go to graduation, or if you have a family member that's going to have surgery, you'd rather work overtime and then take that time off. You can't buy time. Time is finite. And so it's remarkable to me that they would want to deny the same opportunity that public sector workers have to the private sector. It just doesn't make any sense. They're treating private sector workers as second-class citizens in this respect. And yet they say they are defending them. No, they're not. They're treating them worse than public sector workers. I think both the public sector and the private sector should have this choice. The other thing that it's clear to me, unfortunately, our colleagues on the other side of the aisle, that not many of them have been in the private sector, because every private sector person I know cherishes their employees. You go around all over this country, and there are help wanted signs out everywhere. And what people are doing is everything they can to hold on to their workers, not drive them away, because they know how hard it is to get people to work. And so this is, the attitude toward employers, which is so negative, it's just not been my experience in life.
I want to ask a follow-up question, but I want Mr. Polis to feel free to defend that question.
Yeah, thank you. And I as the chair, both chairs know, I employed hundreds of people in the private sector before I came here. And yes, we do cherish our employees. And of course, the flip side of the case where there's a help wanted sign in every window is we all know there's a lot of people out of work as well. There's towns in my state where we have 15 to 20% unemployment, where the main employers left town. There's people who have a harder time just get by. There's also a lot of people underemployed, people with college degrees that are working minimum wage in retail because they can't find a full-time job to support their families. But let me address the first point with regard to the public sector jobs. Public sector jobs have protections that private sector jobs don't have. So a lot of the case I made was predicated on the fact that we're worried about discrimination against employees who refuse to take this comp time. In the public sector, there's strong employee protections. If part of this discussion we're extending those same kind of protections to private sector employers, I think you'd have the basis of a bipartisan compromise where we might be able to empower workers. But if you do that in the absence of giving workers in the private sector the same kinds of protections that public sector workers have, you're actually removing the ability of workers to chart their own destiny, as this bill does, by making them subject to the whims of their employer.
Okay. The follow-up question I had, Chairwoman Fox, is, isn't this a netting out process where I don't pay you any less and you don't work anymore? You're the one that asked for it. I see the need to be flexible. If you don't want to take it, you can ask to be paid. If I don't want to pay you the overtime, I won't ask you to do it. But it could come at either one of our opportunities to say, hey, boss, I've got something next week. Would you mind if I do this? If I take the equal amount of time and then equal amount of work and I still get paid, because I really do want to get paid, but I really don't want to get docked, but I really want to have the flexibility. Isn't that what this is about, a netting out?
The employee holds all the cards. Contrary to what my colleague is saying, it's entirely up to the employee. If the employee wants to continue to be paid overtime, the employee can continue to be paid overtime. If the employee wants to take comp time, the employee and the employer have made an agreement in advance, and the employee can move back and forth at will. At will.
On agreement.
It's a choice of the employee that the employee does not have now.
Yes, sir.
And if I may, it's not a choice of the employee whether the business succeeds or fails. Businesses go out of business all the time in this country, and if something ceases to be an ongoing concern, no fault at all to the line-level employee doing what they were instructed to do by their owners and their managers, the employee risks receiving no payment. So effectively, they are being asked to gamble upon something that they have no say over, namely the success or failure of the business. And in the private sector, businesses succeed and businesses fail every day, every year, and that's all part of the process. And when they do fail, among those that we want to make sure are protected and are paid should be employees whose work is already done. They shouldn't have to get in line with other creditors. They should be paid from the money that exists at that time to compensate them.
Well,
Mr. Chairman, if I might, this is a stretch to say that putting in this policy might cause businesses to go out of business. That's a stretch. If the employee wants to take the comp time, the employee can do that at any stage that is mutually agreed upon. So saying they have to bank it and may risk not getting the money, that's a figment of their imagination.
Let me clarify. No, I did not say that this bill would cause, or employees taking comp time would cause businesses to go bankrupt. The point I'm making is businesses go out of business all the time, with or without this bill. This doesn't change that one way or the other. What this does impact is when businesses go out of business, which they always do, employees who have deferred their overtime compensation for comp time might never receive that comp time. It's very real. It'll happen because businesses go out of business all the time. So there will absolutely be employees who have deferred their comp time and then are then unable to be paid by insolvent businesses after those businesses go out of business.
Madam Chairman, may a business require a person to take comp time?
No, sir. And you know, an asteroid may hit this country one of these days, so
Well,
there are all kinds of possibilities to things that could happen.
And doesn't it have to happen within the pay period that we were talking about?
No, the employee chooses when to take the comp time.
Oh, by agreement?
They could save up weeks of comp time if they want to. It's entirely up to the employee.
I love that. Well, it's flexibility I wish I had. I'll tell you, in the business, when I was in it, a number of women wished they had had it when I was there because it was a flexibility for them and to do things. Thank you very much. Dr. Burgess. Gentleman does not seek time.
Yeah.
Gentleman from
Well,
Massachusetts,
let me
Mr.
ask-
McGovern.
Well, thank you. Well, let me ask unanimous consent to put into the record a letter from the Leadership Conference on Civil and Human Rights, which represents over 210 national organizations to promote and protect the rights of all people in the United States. A letter in strong opposition to this bill.
You'd wish to have that in the record,
I
gentleman?
do,
Without
yes.
objection, I'll be in the record.
But I just asked my colleague, Mr. Polis, I mean, are there any guarantees to ensure that employers don't abuse this system? I mean, that was not,
Absolutely not. There's, and again, there's this concept of, is it the employee's choice? Well, is it really the employee's choice if they're denied overtime hours because they're not using the comp time? And there's nothing to prevent employers from using this instrument of who's willing to defer their overtime for comp time in determining who even gets those opportunities to do overtime. So
are there sufficient safeguards against employers giving overtime work only to those employees opting to take comp time because that's cheaper for the employer's bottom line?
no protections whatsoever, which is another fundamental difference between the public sector employees and the private sector employees.
Anyway, we've made these arguments over and over and over again in the past, and I'm sure you'll make them again tomorrow on the floor. But I think there's a reason why organizations that represent working people, especially women and minorities, are very strongly opposed to this. Mr. Polis?
Yeah, and when we're talking about companies going out of business, we're not talking about asteroids hitting the planet. We're talking about simple facts that 59%, for instance, of restaurants go out of business within 3 years. A majority of new businesses fail. As an entrepreneur and risk taker, I appreciate that. I've had failures as well as successes too. So the majority of new businesses fail. And when new businesses fail, it's appropriate, of course. Investors lose their money. There's some vendors who take a haircut on what they're owed. But employees who have already done their work should not be denied their pay.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Give me your back time. Thank you very much. Any other member of the committee seek time? A gentleman from Alabama, Mr. Burns.
Yes, sir. This was an area of the law that I practiced in. And here's how it would happen. I would get a call from one of my clients and say, all right, one of my best employees came to see me, and she's got something coming up for one of her children, and she wants to be able to bank her overtime so that she can go do a school project or a school trip or whatever. Can I do that? No, you can't do that. Why not? Wage and hour law won't let you do that. I never had an employer call me and say, I want to do this. They always call and said, so-and-so employee or my best employee called and wanted to do it. It's always the employee's idea. It's a little difficult for the employer to handle this, by the way, because they got to set up a system and they got to make sure they're in compliance with the system, et cetera, because if they don't, and there's a violation here, it can really hurt the employer because it's not just double the damages. It's also the attorney's fees. And I'm an attorney. I'm certainly not going to be critical about lawyers charging attorneys' fees, but they can be pretty significant. So there's every reason for the employer to say, look, I just don't want to fool with this. So this bill is really for those employees. And what we found out is that with the millennials being in the workforce now, we have a high percentage of moms and dads, same children, working. And somebody's got to be there to work, to be doing this stuff with the kids, and they're desperately looking for ways to do that, and this is a way for them to do that frankly works for everybody. Now, you know, wages are a priority debt in bankruptcy. It's not like they get thrown in there treated the same way as any other creditor of the bankrupt. So wages are going to get paid first. And in my experience, and it's been some time since I've done this, in my experience, wages are done that quickly. I mean, it's the one thing that you don't really have an argument over. The protections that are in the bill for private sector workers are exactly the protections that are in present law for public sector workers. So there's no difference in the protections with regard to this particular type of activity. So it doesn't matter whether you're in the private sector or public sector, the same protections are going to be there. And the coercion or intimidation is specifically prohibited in the bill. And if you violate that, it's like any other violation of the wage and hour law. It's very serious. I can tell you, the people that I dealt with as a lawyer, the last thing in the world they wanted was a problem with wage and hour division. And most of them, all of the ones that I had interaction with, they were looking for ways to work with their employees. This is a good employee. She wants to be able to do this. I want to be able to do it with this employee. They're looking for ways to, as you said, to keep good employees, not run them off or mistreat them. Now, are there bad actors out there? There's bad actors in everything. And that's why there are protections both in the bill and in the present laws as it protects public sector workers to have a way for bad actors to have to pay a price. And so I've just been listening to the colloquy, and I just got to say, based upon my experience, I'm going to add a little piece to it here. I also had to run a law firm one time and had to deal with an employee that wanted to do this, and I couldn't give it to her, and I felt badly about it. Then I got to be a manager in a public sector environment, and I didn't think I could do it, and I found out I could. I thought, and I didn't realize that there was a public sector way you could do this. And boy, what a joy that was to work with that employee and work it out where I could give this comp time to them, and that would something that worked for them. As I say, it's really not for the employer. It's sort of a extra burden for the employer to do this. But this is a voluntary thing, and if somebody voluntarily comes and says, I want this comp time, I don't think the federal law should get in the way, say they can't. So I'm looking forward to handling the rule tomorrow. I understand Mr. Polis is going to be there on the other side, and he and I get to do this in more detail. So you about.
Thank you very much. The gentleman from Florida, Judge Hasty.
Thank you very much,
Yes, sir.
Mr. Chairman. I kind of like have a pop quiz for all of us, and that's what do the following bills have in common? H.R. 1180, H.R. 465, H.R. 1406, H.R. 1982, H.R. 1380, and H.R. 1 and H.R. 2391. The answer, I'm sure you've all guessed by now, is that they are all iterations of the Working Families Flexibility Act. This bill has been introduced repeatedly in 1997, 03, 08, 09, 2013, 2015, and now in 2017. And while it may very well be that some, or particularly the Chamber of Commerce, may support this measure, there is a long list of people who make their living at the workplace that are very much opposed and have indicated same. The American Association of University Women, American Federation of State, County, and Municipal Employees, the Association of University Centers on Disabilities, Center for Effective Government, Coalition of Labor Union Women, Coalition of Human Needs, DC Jobs with Justice, DEMOS, Economic Policy Institute, Family Values of Work, Jobs with Justice, the Legal Aid Society, the National Council of Jewish Women, the National Council of La Raza, the National Domestic Workers Alliance. And I guess without having to read them all, Mr. Chairman, I'd just like to have the list of workers, if you would allow for unanimous consent, for that list to be made a part of.
Without objection, I'll be into the record.
And let me ask Mr. Polis to, or Dr. Fox, and welcome back, Dr. Fox. And it seems in this measure that the comp time can be provided if it doesn't unduly disrupt the operations of the employer. Does the measure define what unduly disrupt operations is?
Does it say what?
Does it define unduly disrupt operations?
Yes, it's, again, the same standard used for 30 years in the public sector to ensure that critical functions of government agencies continue. It's also the same standard Congress enacted in the Bipartisan Family and Medical Leave Act. There's no evidence that the unduly disrupt standard has undermined the ability of employees to enjoy the benefits provided by the FMLA. The same is true for workers who have access to comp time in the public sector.
I would just add, with all of these, comparisons to the public sector, again, if there was interest in extending the same types of protections that already exist in the public sector to the private sector, there'd be a much more fruitful grounds for discussion. Democrats certainly don't take issue with comp time in the public sector because we have those workplace protections. And if there is a legitimate effort to enhance workplace protections in the private sector, and part of that was to provide more flexibility for overtime, we'd be happy to have that discussion.
Well,
Well, I believe that Mr. Byrne just stated that protections are the same for the private and the public.
well, what's the recourse for a worker who feels that they've been taken advantage of because they didn't unduly disrupt? Is there a recourse?
Well, there is. They can file a complaint against the employer, and their legal fees will be paid, and they get paid 2 times what they would have been paid. So there's certainly recourse for them. And by the way, Mr. Chairman, I think I'd like to point out that that might sound like an impressive list of organizations and groups that oppose this legislation, but I remind my colleagues that only 7% of private sector employees are represented by unions in this country. It's a pretty small number. And to have the public sector employees come out against this, what in the world would they want to do that for?
Well,
Doesn't make a bit of
it must be an
sense.
indication that it doesn't work in the public sector. Evidently, this does not work very well, and so they're trying to apply that. Although I've heard no evidence of that, but it seemed like it doesn't work well, so.
I would urge, Dr. Fox, that many of the organizations that are on this list that I didn't proceed to read all of them are not labor union organizations. They may be, in your mind, people who are working people, and yes, there are on this list people like UAW, but the simple fact of the matter is the National Council of Jewish Women isn't a labor organization. La Raza isn't a labor organization. The Domestic Workers Alliance, and maybe you can pitch them as being labor-minded in light of the fact that they do, in fact, represent working organizations or carry the workers' point of view. I just say that if it's so good, then why are so many organizations opposed to it? Or for that matter, why didn't it become law when I first came here, and in '03 and all these other times that it's been here? I yield, Mr. Chair.
Gentleman yield back his time? Yes, sir. Gentleman yields back his time. Thank you very much. Is there any other member that would seek time from the committee? Thank you very much. Both of you not only have done a job worth coming back for, but I appreciate you not only bringing the ideas to us, with your ideas behind it that support the thesis that you proposed, and those people that might be in favor. And I want to thank you very much. Mrs. Fox, thank you for letting us
you
get on
very
your dance
much
card.
for
I know
the-
you miss us.
Thank you for the welcome. I do miss you all. I almost came over late the other night. I was working in my office, and I almost came over to offer my moral support. And then I thought, I don't want to slow down the meeting one bit. They'll make nice comments, and it'd be better if I just let them get through that meeting. But
Well-
thank you guys very much.
Well, the fact's the
And gals.
case. I gave comp time that night, and I said, if you will take a couple hours for dinner, I'll have us work a couple hours a little bit later, and everybody agreed, and everybody was here, virtually everybody, so we made our comp time work okay. We missed you a lot, Virginia. Thank you very much. Is there any other member that would seek to give feedback on H.R. 1180, Working Families Flexibility Act 2017? Seeing none, the chair will now close the hearing portion of H.R. 1180, Working Families Flexibility Act of 2017. Chair would now be in receipt of a motion from the young chairman from Oklahoma. The gentleman is recognized.
Mr. Chairman, I move that the committee grant H.R. 1180.
Excuse me just a moment, please. We've got a stenographer that needs to make sure she can hear the words that are being spoken. I appreciate order in the committee. The gentleman is now recognized.
Mr. Chairman, I move the committee grant H.R. 1180, the Working Families Flexibility Act of 2017, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-15 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides that on any legislative day during the period from May 5th, 2017 through May 15th, 2017, the journal of the proceedings of the previous day shall be considered as approved, and the chair shall at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring such the adjournment. Section 3 of the rule provides that the Speaker may appoint members to perform the duties of chair for the duration of the period addressed by Section 2. Section 4 of the bill provides it shall be in order at any time on the legislative day of May 4th, 2017, or May 5th, 2017, for the Speaker to entertain motions that the House suspend the rules, and the Speaker or his designee shall consult with the minority leader and or her designee on the designation of any matter for consideration pursuant to this section. Finally, Section 5 of the rule waives the requirement of Clause 6A of Rule 13 for a two-thirds vote to consider a report from the Committee on Rules on the same day it is presented to the House with respect to any resolution reported through the legislative day of May 5th, 2017.
You now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion to that? Gentleman from
Yeah,
Massachusetts.
so, Mr. Chairman, I think it's worth pointing out, this is the 30th closed rule of this session. And so that's it's record-breaking in and of itself. But, you can't help but comment on the fact that last week we faced a Friday night government shutdown. We faced the threat that you guys might bring up another version of your disastrous health care bill, which would throw millions of people off of health insurance and wouldn't protect people with pre-existing conditions. And then you implemented a martial law rule for any bill. And so this feels like Groundhog's Day. I keep waiting for Bill Murray to drive his truck off the cliff because we are virtually in the same place this week, facing a Friday shutdown deadline, the threat of health care repeal, and blanket martial law. Now, I'm happy when I'm reading in the press that we seem to have a real appropriations bill rather than another CR, but I think we all know it shouldn't have taken so long. This was a manufactured crisis, but here we are again facing the threat of health care repeal. And if you all say you don't want to rush this bill, then I don't know why you're using these extraordinary martial law procedures. We have the one-day layover rule to make sure that members and the public at least have 1 day to review very complicated rules that come out of this committee. So, and lastly, I just would like to point out that, and this is why some of us have a lot of concern, we're getting conflicting information on this repeal bill, and facts are a stubborn thing. The new bill would gut pre-existing conditions and take away essential health benefit protections. But then on CBS this weekend, the president said the exact opposite. And I ask unanimous consent to insert in the record an article from Vox titled, "An Interview Suggests Trump Doesn't Know What's in His Health Bill." I mean, he says that people with pre-existing conditions will be protected under the amendment that, at least the latest version of the amendment that we had in the Rules Committee. That's not that you negotiated with the Freedom Caucus. That's not the case. He said that deductibles will go down under the Republican plan. Well, we have nonpartisan analysis that expects deductibles will go up. So the bill that Trump was describing on Face the Nation is not the bill that my friends have been talking about here in the House. I also want to ask unanimous consent to insert in the record a letter from the American Medical Association that continues to be very, very strongly opposed to the health care repeal bill, especially with the MacArthur Amendment. And one of the things they say in the letter is that the current ban on health status underwriting health status underwriting protects individuals from being discriminated against by virtue of their medical conditions. Prior to the passage of the ACA, such individuals were routinely denied coverage and are priced out of affordable coverage. We are particularly concerned about allowing states to waive this requirement because it will likely lead to patients losing their coverage. So we, on behalf of our constituents, continue to be concerned about these kind of heavy-handed rules that allow the majority to bring up, without a one-day layover, without kind of going through the kind of process that would allow us to read what's in your bill, but would allow you to bring something like this to the floor on an issue that impacts so many people. So we have some concerns. I yield to my colleague.
Thank you very much. Mr. Chairman, I echo the expressions made by my colleague. And last week, I commented with reference to the continuing resolution that I doubted very seriously if 400 members of the House of Representatives had any idea about the particulars of that measure. I think it's a failing in this institution on behalf of the majority and the minority to use the top-down approach where a handful of people are involved in negotiations, and those of us that have labored in the vineyards just as long as they have no input. We read about it in the newspaper or hear about it on television, and I don't think that's right. But what Mr. McGovern is pointing out is the process that we are utilizing in this committee allows, among other things, that we have the continuing use of closed rules, continuing use of martial law, and what that leads to is a significant number of members are being not only backbenchers, but off the bench because they don't know what in the world is going on in this place. And that's why time is needed in order for members to have an opportunity for they and their staffs to come up to speed. So, Mr. Chairman, I have an amendment to the rule, and I move the committee amend the rule to limit the waiver of Clause 6A of the Rule 13 to apply only to measures related to appropriations. And I don't think that's at all unreasonable.
Thank you very much. You've now heard the motion. Discussion.
Mr. Chairman?
Yes, sir. Gentleman from Georgia.
Mr. Chairman, I had the pleasure of defending the rule that did all of these same things last week, and I agree with my friend, Mr. McGovern. It is a little bit like Groundhog Day. We're hearing all the predictions of all the dire consequences that will happen if the Rules Committee acts on this bill, and none of those dire consequences came to fruition last week, and none of those dire consequences are going to come to fruition this week. No one is suggesting that you change the requirement and practice that folks have 3 days to take a look at legislation. Nobody's suggesting that we're going to jam something through the floor through this process that we couldn't get through the process anyway, but there is a sense of urgency, and I think my friends would agree with me that once we get past this healthcare conversation, it's not lost on me that we've asked unanimous consent to put an AMA letter on healthcare into the record on the Education and Workforce Committee's bill today, because we are so collectively obsessed with the healthcare conversation, because it's important to folks back home. But once we get through this process, we're going to be able to focus on everything else that's important to each and every one of us. If the chairman has done anything in the time that I have served with him, it is to earn my trust and confidence that, yes, these are expedited procedures that the Rules Committee has used in the entire 20 years I've been following this institution. And I have more faith and confidence that our chairman, as he sits here today, will not use these provisions in a way that would make us ashamed, but would use them in a way.
Would the gentleman yield?
Be happy to yield.
Then why put them in the rule?
Reclaiming my time, as my friend knows, expedited procedures matter. My friend doesn't want to be here on Saturday when he can vote on Friday. My friend, after he has read the entire appropriations bill that gets posted on a Tuesday, doesn't want to still sit here on a Sunday talking about it. He wants to get the show on the road. I've never seen the chairman take away our opportunity to take a look at the material. He's only saying that we remove the layover requirement for a rule and not for the underlying legislation.
Gentleman yield?
Be happy to yield.
I don't think we're that upset about the fact that we want to keep the government running, and if we have the chance of passing an omnibus bill, that we should do that. And, and that, I don't think that's what we're expressing anxiety about. It's the thought that a health care bill that the President of the United States doesn't know anything about, apparently, based on the interview he did on a talk show over the weekend, might somehow appear, and that people will not have had an opportunity to really know what's in it. And
Gentleman yield?
I'm happy to yield.
We've been given lots of time. Even the American Medical Association has
Right.
had time to
Well,
review the bill.
So if the gentleman's,
And one other
assure
thing.
us that any health care bill that would come to the floor would be exactly what has been posted in terms of the MacArthur Amendment and no other additional changes, then he can make.
Well, I can't do that. What I can tell you is we'll come back to the Rules Committee.
Right, we can come back and make all the necessary changes. Not a single hearing has been held on any of the healthcare legislation that we have contemplated, other than here in the Rules Committee, but none of the committees with jurisdiction
Well,
have done it.
that's partially true. As you know, the Ways and Means Committee had extensive hearings. Energy and Commerce had extensive hearings. We met probably 25 hours.
I know they did a markup, I don't know they did a hearing. Maybe,
Well, they have done hearings.
not this year, to my knowledge. I mean, I don't know, and certainly not under anything we're going to be potentially talking about. I guess the point of the matter is, if this is
Well, we
only-
have been talking about it for
Right.
several months.
If this is only about the omnibus, that's one thing. And I think what the gentleman from Florida is saying is that if that's all it's about, then let's just say that's what it's about. If you want to throw in a couple of suspension stuff, that's fine. We can live with that too. But, I mean, we just have, the way the majority is approaching this healthcare debate, I don't think serves this institution very well.
Okay.
And we are very concerned about the impact it will have on our constituents. So that's why I support the gentleman's amendment.
Okay. The gentleman still holds the time.
I yield back, Mr. Chairman.
Gentleman yields back time. I would just like to add one more thing as to the closed rule. I'm not sensitive about it, but we put a call out for amendments and did not receive any.
So let me ask you this, would it have been an open rule if we had 100?
I don't think that's my point. I think my point would be where we did not receive anybody, nobody chose to bring anything up here, so we said we're going to get on with our work. So same thing happens up here.
Mr. Chairman?
Yes, sir.
You know what happens when things become perfunctory? People tend to believe that that's how it's going to function. Now, you and I know that under open rules, a person may very well on the floor have an idea that they can present. And that's, we're doing ourselves a disservice. However, if you're going to continue down that path, then you're making all of us become robotized.
Well,
when
I'll
all is
just
said
ask
and
the
done.
gentleman, what would you, except for an open rule that I don't think we want to all get into to amend things that might impact a number of people without conversation. What would you want to have done in a modified or structured rule?
In this particular measure or any measure?
Well, as it relates to the Working Families Flexibility Act.
In this particular measure, I would have presented all of the arguments that you heard from Mr. Polis and Mr. McGovern, and likely would have been in a position to prepare an amendment that might be germane or that would cause some of the people in this institution.
But that was open to anybody if they'd want to bring an
I
amendment.
understand your point. All I'm saying to you is if we get used to the notion.
Well, I
that
completely agree with you.
Yeah.
And I do too. And that's why I think and I think the gentleman from Georgia may have been very kind to me. I try and have full debate in this committee and ask as many questions as I can. Some of them are even related to understandings that I don't think any of us have had, and I try and delve and probe. And I think every member of this committee does the same thing, and I think you do too. And that is a beauty of this committee with our opportunity. But in this case, we heard both sides.
Well, Mr. Chairman, if I
Yes,
may,
sir.
I just would say, just for the record, that open and responsible governance requires that we default to open rules whenever possible, and not this closed process that doesn't even permit amendments to fix a typo. And a debate in our committee and on the floor, I mean, if somebody's watching this being streamed live, I feel bad for them if they are, but if they are, they may get an idea that they might be inspired to offer an amendment on the floor, and, they won't have that opportunity. So
But the gentleman knows in this case, all we're doing is offering one side of the enterprise system with the other side. That's all we're doing. We are not actually going and putting somebody at a difference or at a disadvantage. All we're trying to do is equal. That's all we're trying to do. And I think that does cause heartburn for people if they say, boy, let's fight that. I think fair is fair, and that's all we're trying to say.
I would just say that I don't think we would be prolonging this if the rule were just simple, it was just a simple closed rule.
But you and I both know what it is.
Or they provided expedited procedures to bring up an omnibus bill.
Yes, sir.
Or something uncontroversial.
Yes, sir.
The reason why we have great anxiety here is because the fact is that a major health care bill might suddenly appear.
And I acknowledge
Could impact tens of millions of people in this country, and under a process that won't give anybody the opportunity to know what the hell
Yes, sir.
it does. So that's what our objection is.
Further debate.
All right.
See none, the motion is now on the floor, the amendment from the gentleman from Florida. Those in favor of the Hastings amendment signify by saying aye.
Aye.
Those opposed, no.
I ask for.
No. The gentleman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? No. Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Buck? No. Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
The amendment is not agreed to, not agreed to. Further amendment or discussion? Any discussions? No discussion. We'll move now to the motion. Those in favor of the motion from the gentleman from Oklahoma signify by saying aye. Aye. And those opposed? No?
No.
The ayes have it. The ayes have it. Accordingly, the gentleman from Massachusetts asks for roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Aye. Mr. Burgess, aye. Mr. Collins? Aye. Mr. Collins, aye. Mr. Byrne? Aye. Mr. Byrne, aye. Mr. Newhouse? Mr. Buck? Aye. Mr. Buck, aye. Ms. Cheney? Ms. Cheney, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings?
No.
Mr. Hastings, no. Mr. Polis?
No.
Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 3 nays.
The motion is agreed to. Accordingly, the gentleman, Mr. Byrne from Alabama, will be handling this for Republicans.
Mr. Polish from Colorado will be handling for us.
And they will be handling that for Democrats. Good luck. Thank you to both of you.
Chairman, you're going to address
Just
the rest
one
of the
second, please.
schedule?
Tomorrow, we will meet at 3 o'clock on the omnibus. Is there further discussion from
No,
anybody
just
on the
one to
committee?
know.
Is there any committee members? Thank you very much. We've now completed our work for the day.